come you don't have your right hand there? Your right hand. Listen.
No one can replace you.
Good afternoon, everyone, and welcome to the Delaware Public Service Commission meeting of June 18th. We have a reading of the meeting minutes of June the 4th. Does any commissioner have any corrections or changes to the minutes?
Move we adopt the minutes as presented.
I second it.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Is there any abstentions? Motion carries. This is also, as part of the beginning of the meeting, we had a big loss, so to speak, with Jerry Platt leaving as our engineer. But Raj and team went to work, and we have now a gentleman, if he would rise, Wayne Erickson, who's our new guy. And so welcome aboard, Wayne, and best wishes. And I know that you're going to enjoy yourself, and we'll enjoy hearing from you in the future. Numbers 3, 4, 5, 6, 7, 8, 9, 10, and 11 involve the distribution system.
Yeah, consent agenda.
Involve the distribution system improvement plans or compensation. And I know that we have Tidewater, Suez, Artesian, Chesapeake, and Delmarva present. Do any of those parties or staff have any objection to those matters being placed upon the consent agenda? Hearing no objection, those matters, items number 3 to 11, are hereby placed on the consent agenda. Is there anyone here from the public that wished to speak to items number 3 through 11 involving the distribution system improvement charge? I don't see anybody in the public that's here on that issue. Those matters are now added to the consent agenda. Any item on the consent agenda that any commissioner wishes to have removed?
Mr. Chair, I have a question on item 6 on the consent agenda. I'm not sure it needs to be removed, but in the supporting materials, there is a response request of 10 days for Delmarva, and I didn't see any indication. So we can either address the question now or set it aside.
I think that you should talk to Shona off time and just ask her that question. Is she here? I don't. Oh, okay.
Is there such a commitment as is in the supporting materials, requested a 10-day turnaround?
What do you mean by there?
There's information requested from Delmarva, and it looks like it is and has been requested within 10 days.
Yes.
So I'm just asking, have you received a commitment that that will happen?
No, but I'm guessing if it is approved, then that would be the obligation.
Okay, then I have no further questions, Mr. Chair. Thank you very much.
Thank you. May we have a motion with respect to the consent agenda?
I move that we adopt the consent agenda.
I second.
Is there any discussion on the motion to approve the consent agenda? Hearing no comments, all those in favor signify by saying aye.
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 Are there any opposed? Any abstentions? The motion carries. Okay, number 1 on the regular agenda is in the matter of the review of customer choice in the state of Delaware. Would the parties please come to the front table? Ms. Orr, welcome, and please lead us off in this matter.
Thank you, Chair Winslow and Commissioners. Good afternoon. Lindsay Orr on behalf of Delmarva Power, and with me is Diane Goff. You have in front of you today order number 9384, which approves the discount rate contained in Delmarva's purchase of receivables, or POR, discount rate filing. The POR filing was made in compliance with Commission Order number 9220 in the Customer Choice docket. The discount rate is a calculation to be applied to the POR payments submitted to electric choice suppliers that have been certified by the Commission to sell electricity to customers in Delaware, and is not a rate charged directly to customers. As you may recall, we were before you last month and requested a delay in implementation from June 1st to July 1st due to testing not being complete. Testing has now been completed and we are ready to move forward with implementation. As mentioned last month, we are going to purchase the receivables back to May 2nd so the suppliers will not be affected. We appreciate staff's review of Delmarva's POR filing and preparation of the proposed order. We are in agreement with the form of order in front of you today, and accordingly, Delmarva Power respectfully requests the Commission enter order number 9384.
Thank you, Ms. Orr.
Thank you.
Mr. Walsh.
Thank you, Chairman, Commissioners. Ms. Orr's recitation is correct, and I will also note that we did amend the whereas clause, I believe the second whereas clause in the order to delete June 1st and put in July 1st, 2019 as the date for Delmarva to implement the POR. Staff has reviewed the filing, finds it to be in compliance with Order 9220 as referenced, and recommends that the Commission approve the discount rate contained in the filing and approve proposed form of Order 9384.
Thank you, Mr. Walsh. Mr. Slater?
The DPA has nothing to add. Mr. Walsh did a fine job. Thank you.
And Mr. Green, who represents RISA, is not present for that, I assume, because of he's not on the telephone, I don't believe. Obviously, he's from Virginia, so it's very understandable he wouldn't show up for what appears to be basically a settled matter. Commissioners, any motion for this?
Mr. Chair, I have a question, please.
Sure, please.
So are the discount rates set to only offset the $30,000 a year to implement the program? And will any over or under collections affect either the rate base or the ROI?
The discount is only including the estimated cost for I think it's being recovered over 5 years, so it's a fifth of it. I don't recall specifically whether it was 3 or 5. But any over or under collection is built into the next year's POR rate. It does not go back to shareholders or to customers.
No further questions, Mr. Chair.
Thanks,
Thank you very much.
Commissioner.
Mr. Chair, I move that the Commission adopt order number 9384.
I second.
Any discussion on the motion to approve order number 9384? Hearing none, all those in favor signify by saying aye. Aye. Any opposed? Any abstentions? The motion carries. Thank you, Ms. Orr, Mr. Walsh, Mr. Slater. Number 2, in the matter of the application of Verizon Delaware LLC, et cetera, I don't see any representative from Verizon here. However, Mr. Willard is present to handle this matter.
Yes, Your Honor. This is order number 9402. We're asking you to approve. This is a cable TV renewal by Verizon. This is a franchise that was issued in 2006. It expires in 2021. It's a 15-year franchise. And they're allowed to come in up to 36 months before it expires to try and start the renewal process. This is under Section 626 of the Cable Communications Policy Act of the federal government, found in Title 47 of the United States Code. The order calls for Mark Lawrence to become the hearing examiner and to hold public comment sessions in all 3 counties. Comments will be due by October 25th. Petitions to intervene will be heard considered by August 8th, or must be filed by August 8th. And they may submit a proposal for renewal by October 31st. They then will prepare a franchise agreement which staff will review and either negotiate changes or approve the franchise agreement. Trish Gannon is here if there's any other questions of the commission. Otherwise, we ask you to approve order number 9402, opening this docket.
Thank you, Mr. Willard. Mr. Slater?
The DPA has nothing to add. Thank you, Mr. Chair.
Thank you, sir. Commissioners, any questions?
Move we adopt order number 9402 as presented.
I second.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, Mr. Willard. Mr. Slater. Next item on the calendar is item number 12, in the matter of the application of Delmarva Power and Light Company for approval of a program for plug-in vehicle charging. And this matter was heard, I believe, on June the 4th by this commission. And Ms. Orr is coming forward. And Mr. Tweedy is here. I thought I saw him walk in. Are you going to come up to the table, sir? And we've got Mr. Slater here, and we've got Mr. Walsh here for staff. The commission decided this matter last time, and one of the matters that was contested, or the only matter really contested, was something that wasn't part of the agreement of the parties that was approved by the commission. And that was the fact that approximately 21 pages of the hearing examiner's order were public comment, quotes of public comments by people who made public comments to the Public Service Commission. Now, as a matter of background, as I think I stated the last time we were here, I have been in cases where I've had up to 500 documents from members of the public that were public comment that were sent to me by this commission to review, read as part of the public comments section. I've had other cases more recently where the public comments are summarized and I have not received a copy of them. And I guess maybe I should have asked what happened, why didn't I get the original copies, but I guess maybe I took the easy way and decided to take the summarization. Now, I get the point from the DPA that 21 pages of quotes from various people in favor of, not all, but most of them in favor of the agreement or in favor of electric vehicles is certainly a very thorough job, if not, maybe a little bit over the top. But I can also see how someone who's sitting down at their work table and trying to come up with an order on a very important matter that involved a certain amount of testimony and discovery would utilize his ability to copy and paste and put in the public comments as part of the decision and part of the 21 pages. And I, to be very frank with you, was having had read the order, et cetera, I was a little bit surprised that the DPA was so concerned about me getting too much information from the people who were making public comment. I mean, I think it's pretty evident that the public comment is a public comment. I guess we encourage the public to come and make public comment at our meetings. We encourage them to give us their input with respect to various matters that come before us. We encourage the public to participate. We wish they would participate more, not less. And so we had this decision, and just like the separation agreement says, where there's a separation agreement, but if there's a difference of opinion in some of this, and we're going to have subsequent hearings, perhaps on whether or not it's going to be part of rate base, how much they can charge for the various meters they put in, and that that no one can really. In other words, the public comment wasn't really part of that whole discussion. If you look at the agreement between the parties, public comment's not mentioned there. If you go to the findings of the hearing examiner, he doesn't. My recollection, I reviewed it again today. I don't see where he mentioned the public comments at all. And to assume just because there's 21 pages worth of public comments, or that perhaps in some estimations the public comments were given some undue influence, I certainly didn't feel it. I found that the public comments were by and large informative and on point and were interesting because you can see the pros and cons of the issue. But I think it was pretty clear what the commission decided to do was make a decision on the evidence that was on the record, untainted by the public comments, and I believe that's what occurred. And I don't believe that what's been filed by the DPA as for a motion for a rehearing really brings anything new to the table that we didn't already hear. And so I'm going to make a motion and put it on the table. Haven't talked to the other commissioners about the issue, but we'll find out what they feel. But in my opinion, our previous order was not founded in even a single solitary little iota based upon the public comment. That was informative, not part of our process of making a decision. So I'm going to move that the DPA's motion for rehearing be denied, that everything stay the same as it was before, with the additional comments of the commissioners being part of the record now being made, so that any commissioner who wishes to disagree with me is quite willing to do so, or affirm whichever they wish to do, or make entirely different comments. But I would like that this motion, I'd like to get a second, so this motion will be subject to discussion amongst the commissioners, and then we can move on. I don't think that additional oral argument is something that we need to hear from unless Mr. Slater insists that there's something entirely outside of what's been in the writing so far, and both of these times we've met. And if he says that there is something outside those four corners, you know, we will all very happily listen to him. The same with Ms. Orr, Mr. Tweedy, and Mr. Walsh. So before we go into, well, let me get a second on the motion.
I'll second the motion, Mr. Chair.
Mr. Slater?
Well, it seems kind of pointless now that you have a second for me to comment on our motion, but you know, part of our request for rehearing was that there wasn't an explanation in the order, which would actually make it appealable, which I believe is under 503 of the Delaware Code. So if this is how you choose to proceed, I want to make sure that everybody has each commissioner's understanding so that it could be appealed. So we believe that there was a misapprehension of the law, and that is why we had filed our appeal. We have not said that public comment is not important. It is. Actually, you don't even have to take public comment, but you do. And that is terrific, and it should be commended. I've attended every public comment session possible since I became public advocate, because I want to hear this firsthand, just as we get all the phone calls every day. But having 16 pages or 21 pages when all of your previous cases have been summarized in literally like no more than 2 paragraphs, I think is overdone. And if you choose, I mean, it seems like you've already got a second, so if you choose to go this way, I want to make sure that each commissioner says why they voted, so that it could be appealed, should it be appealed.
Thank you, Mr. Slater. Mr. Tweedy?
Thank you, Your Honor. I'm not aware of a requirement that each commissioner state their reasons for their decision, and it seems pretty clear based on the proceedings that happened here and last time, what the commission's decision was and its careful consideration of the issues. And with the guidance that you do not want to hear things that have already been said, I will try and keep my comments very brief. I think, as I put in Denreck's papers, that the public advocate's motion is procedurally improper for exactly the reason you suggested, that we are here to hear new things, not things that have already been addressed.
Mr. Tweedy, please, I want to hold you to the same standard as Mr. Slater. That's been argued in your response. I mean, we got it, we read it.
Great. If Your Honor has read our response, that is there for all of your consideration. I don't need to belabor the point. Thank you. One of the things we did put in our response is the option, should the commission want to pursue it, to formally amend your order to specifically say what you have now stated, so that there is that clarity should the DPA deem it necessary to appeal this settled docket.
Thank you, Mr. Tweedy. Yes, sir, Mr. Slater.
Thank you, Mr. Chair. So we have no problem with the settlement. This really comes down to the public comment. Section 503B of Title 26, Chapter 1, says that the commission shall make and file its findings with its opinion, if any, and its order thereon. Its findings shall be sufficient detail to enable the court on appeal to determine the question presented by the proceeding and whether proper weight was given to the evidence. That is what we're asking, is that I want to make sure that not only for this case, but any future case, that we have a sufficient detail should something be appealed.
Well, I understand your position for the record, and I would just say that I'm not sure that the public comments are really an issue that we actually decided, other than the fact that they're not part of the record. We didn't consider them as a basis for our agreeing to a settlement, even though obviously a lot of that public comment was supportive of the agreement you all came to. You know, a lot of it was supportive. But the reason we settled it was because, one, the parties settled it. Two, there's statutory authority in the state that says that a settlement is basically looked on with some degree of acceptance. And if there's some substantial evidence in a record, and the hearing examiner set forth what he said were his findings and recommendations, and not anywhere in there is there a mention of public comment. So you may have the right to appeal with respect to that issue, but you know, our decision is based, as I stated, and at least that's part of my motion. And also in your settlement documents, it's sort of like what you said in your settlement documents here. To the extent, this is page 6, to the extent opinions or views were expressed or issues were raised at any point in these proceedings, whether as part of a document filed or otherwise, they are not specifically addressed in this settlement or in this decision by this commission. No findings, recommendations, or positions with respect to such opinions, views, or issues should be implied or inferred. In other words, beyond what I've stated, which is how we made our decision, I don't think anybody, whether it be DENREC in their position that they've tried to take, which is a reasonable position, nor your position, which was reasonable, I don't think you should imply, either expressly or otherwise, anything beyond what I've said our decision was based upon. Now, let me tell you something. After this hearing on June the 4th, I happened to walk out. Mr. Slater and Ms. Iori were there. And they expressed to me at that point in time their concern about this issue. And of course, I knew there was a concern about the issue. So I likewise have a concern about this issue. As I sit here today, I mean, I value the public comment, but there is some ambiguity with respect to, you know, am I supposed to get the entire writing from the person who's making a comment? Am I supposed to get a summarization? That's an issue. And to be frank with you, I don't know what the answer to that is. No one's provided me with any law with respect to that. So what I did was, as a result of my thinking about this particular case, was I called up our executive director and I said I thought that this was an issue worthy of discussing and resolving so that all the parties that come here will understand what role the public comments have in our decisions. I said, as it stands right now, I'm not hearing from the hearing examiner as to why he put in 21 pages of public comments in the way he did. I don't have the ability to hear from Bill O'Brien at Chesapeake or somebody, Lindsay Orr from Delmarva, about their feeling with respect to this. Wouldn't it be better if we were to have a workshop, or call it whatever name you might want, and get the input from everybody, the law from everybody, and this commission go forward and make a decision? If the workshop can't make a decision, then we should make a decision as a commission as to how we want to treat the public comment. Because right now, as I said, I've gotten 500 letters from the public to read. I've gotten none, and I've gotten summarizations. So it is an issue. We all recognize it as an issue. We need to resolve it. This commission has decided we're not going to resolve it in this particular form for the reasons I state. However, we haven't had a vote yet, so that's a problem for me. So right now, I want to hear, and by the way, commissioners, you don't have to say anything at all. But if you want to make some comments, you're perfectly welcome to, whatever they might be. We're just trying to come up with the best result in this particular case. Any commissioners have any comments to make on the record?
Of course, thank you, Mr. Chair. Yes, I would like to make a few comments, inasmuch as I am the commissioner who actually made the motion to adopt the settlement agreement. And I agree with our chairman that in looking at the findings from the hearing examiner, I think that if we are here to serve the public interest, then public commentary sets a context of public interest, but it doesn't mean that that is the scope that we focus on in making our decisions. And so I would agree with the chair that my focus was on the settlement agreement itself and whether, as a commissioner, I could, in the public interest, agree with that settlement agreement. And so that had nothing or very little to do with all of the public commentary. But sometimes I think if you're adjudicating an issue, it's helpful to understand some of the periphery of context in which you're making your decision, but that does not mean those are the facts upon which your decision is based.
Commissioner Drexler?
Yeah, I think that what was important in our last meeting and what came up as over and over again was that public comments are not evidence. We all agreed they're not evidence. I think everybody agrees they're not evidence. The hearing examiner did not make his recommendation based on public comments. He based it on the evidence, and I think everybody agreed on that as well. So really, when you take all that out of it, it comes down to 16 or 21 or whatever it was pages of public comment, and you know, this is electric vehicles. This is new, and I think it's important for us to know what the public is thinking and whether or not it was condensed by the hearing examiner. Is that really? I mean, that was the way the hearing examiner wanted to present it. Whether it was a cut and paste or whether it was, you know, done for a reason, it didn't influence me, and I can only speak for myself as a commissioner. But you know, the evidence was the evidence, and that is what the hearing examiner was charged with doing, and that is what he did. Whether or not it's 16 pages or like Dallas said, 500 letters, it is what it is, and that, you know, there were a lot of public comments, and I was happy to see that. I was happy to see the public comments, but again, you know, the recommendation was based on evidence. That's how I looked at it, and that's how I made my decision. And that's my comment.
Commissioner Conaway?
Yes. When you all came before us, you came before us in agreement to the settlement. It was quite evident that there was a problem with the public input, and the question that arose does need to be settled, as the chair has stated, and I think his suggestion of a workshop is great.
Commissioner Correa?
I was the one who voted against the motion last meeting on June 4th. After listening to Chair Winslow and the 500 versus 500 letters versus none versus 21 or what have you, I am changing my mind in the sense that it is not a precedent setting, which was one of the fears which were expressed at the last meeting. And if it becomes a precedent, Commission certainly can say that no, we don't want it, or we want it. So we have flexibility. We are not relinquishing our powers and or authority over future inclusion or no inclusion. So I think with the idea of workshop, we should go ahead and move towards the resolution which you have proposed.
Commissioners, is there anybody who has any further comments? If not, all those in favor of the motion signify by saying aye.
Aye.
Is there any opposition? Any abstention? The motion carries. Thank you very much, everyone. Okay, the next item is the hearing schedule, and there's nothing on the hearing schedule. And just coincidentally, the next item is...
Commissioner, Chairman, number 13, opening,
Oh, I was gonna skip that and hurry to get the public comment.
the main one, the big one. Off the record.
Yeah, we better do number 13. Number 13 is in the matter of the Delaware Public Service Commission's jurisdiction over electric vehicle charging stations and service providers. I would just like to make a precursor comment on this one as well. Mr. Slater and Dr. Barua and your respective staffs, and also Samantha Hemphill, I believe that all you gentlemen and ladies have made significant efforts to have this issue resolved politically, as was our desire, so that we had the I can't talk today. We had the approval of the legislature. And unfortunately, that didn't happen, and we have put off the decision with respect to CPCNs for about a year and a half, because I don't believe the public advocate nor staff, probably not this commission, believed that it should remain as it is, and that we should enforce that particular provision. So I just wanted to say thank you to all those hardworking people for getting this matter on our calendar for our consideration. And I look forward to hearing what you all come up with as a result of this docket. Any commissioners have any questions from the parties? Do we need to, people want to make a speech on this one? Mr. Slater, you probably, go ahead.
So, allow me to start, Mr.
Please.
Chairman.
Yeah.
I do want to give credit to our public advocate, Drew Slater, for coming up with this idea to fast track it.
You know,
Credit where
please.
credit is due.
Time out. Make something. This alternative has been known since day one. He's not either going to be the savior, nor is he going to be the person who gets knuckled under because we're doing this. This is just prudent, I think.
It is, and I think it also shows some of the interaction that we have in.
Mr. Slater, you have the table.
thank you. Those bus marks feel mighty good today. Notice it has some armor on. Could you, thank you. So Andrew is going to hand out the Public Utilities Act to you. Surprisingly, I actually have to disagree with staff here. I think this is the first time that's really happened. We try not to. So this commission, obviously, as you've already mentioned, Mr. Chairman, has each in the last 2 years determined to wait to see if the General Assembly would act to deregulate electric vehicle charging stations. Staff's petition, I also can't speak today, seeking your relief is before the legislature ends, but that's kind of a minor issue. Section 201D of the Public Utilities Act provides, and I've highlighted it, that the commission may, upon application or on its own motion after notice and hearing, forbear from, deregulate in whole or in part. Staff's petition doesn't meet the application requirement, but it's seeking relief on the commission's own motion. So the DPA respectfully submits that staff's petition's not the commission's own motion, because staff is not the commission. And so I have to respectfully oppose this opening order. You can do so on your own motion, but this is staff seeking a petition for relief, and staff is not you.
Thank you, Mr. Slater.
Clarifying question, Mr. Chair. Mr. Slater, are you saying that it's a process issue for you?
It's not just a process issue, it's a matter of law for me. So you can have an application or you can do so on your own motion, but a petition, the staff's petition is not an application, and it is not your own motion because staff is not you. I fully support opening a docket to do this. I just want to make sure that it is on your own motion and not on staff's motion or my motion or anyone else's, because I don't want to get that far down the road and then have problems. I would rather bring it up today.
Well, I believe that the staff has made an application to this commission. This commission will consider the issues. The parties will probably agree on the resolution, and this commission will make its own motion with respect to the decision, and we can incorporate that we can join ourselves to, if you think it would be appropriate legally, if you want us to, we could, as part of our motion today to open this up, we could incorporate the fact that this commission believes that this, our own motion pursuant to the statute to proceed on this matter. Now, whether that clarifies things and makes you feel happy about it, I don't know, but what is it you would suggest that we do?
I would suggest that staff's motion be denied, but that you enter your own motion, which is, I believe, legally acceptable. I am not an attorney. My right hand is not here today, but that is what I believe the statute says, and I don't want to get down this road and find out that we have to start all over again. That's my concern.
Well, I think that you're being very appropriate about your comments, and I think it's thoughtful, and I think that's important for us to think of. But as I think about procedure around here and what happens as a matter of reality, is that if it's a Delmarva Power and Light order, or they ordinarily write the order, it revolves around staff and the DPA, and corrections are made, and a final order gets to this commission, but it's then becomes the commission's order. So I'm not, can't say that I know the absolute answer to this question, but I think that we're not going to delay this today. We're going to proceed ahead because it's an important issue, and I think we need to go ahead with it. Let's hear from the other parties if we could.
Mr. Chairman, may I just, because it's bothersome to me that, and I'll let your counsel advise you, but I think it's splitting hairs and it's semantics. If the issue with, and I do agree with you a lot, but not in this case, if the issue is that our petition and our memo and our background research is troublesome, then I'm willing to go and change the title of that document to background research. That's all we were trying to provide you. It is whatever you want to decide, whether you want to move forward with this. So that's all I have to say. Thank you.
Mr. Walsh?
Thank you, Chairman, Commissioners. It may just be a matter of semantics, but we are applying by way of our petition, requesting that this commission open a docket to investigate the appropriateness of forbearing from regulation of EV charging stations. It is nothing more than that, the opening of a docket. And we set forth in our petition the bases for that consideration under 26 Del Code 201 D1. I don't believe that the difference between application, petition, and motion in this circumstance carries the day. This is staff's petition requesting the opening of a docket to then consider the forbearance. And we have attached as an Exhibit A the notice which would be published, which brings in the public comments. And we have set forth the background in the petition, which also mentions the memo, which Ms. Gannon to my right put together, which is also part of the agenda, and it sets forth her very well-written research analysis of the various states' treatments of EVs, whether they exempt EVs, I should say electric vehicle supply equipment, from definition of public utilities. And this is a very important issue. It has been well researched. Our petition sets forth the grounds giving this commission authority and certainly the basis it needs to open a docket. Everyone is aware of the development of the EV market and the charging stations in Delaware. The fact that there are many charging stations opened, and the connected issue of the fact that no CPCNs have been obtained by any of those charging stations. And with that, the importance is clear. So we are merely asking that the commission approve an order opening the docket. Whether that is, for some reason, tabled and made by the commission's own motion doesn't seem, for the sake of efficiency, a very proper way to go about this. This is going to happen, and just opening a docket allows all parties, including DPA, of course, to weigh in on this important issue of exempting owners and operators of EV charging stations from this commission's supervision and regulation. So I could get into further details. I don't believe I should need to. The commission has the proposed order 9418, which sets forth the proper whereas clauses describing the background. It incorporates staff's memorandum. It orders publication of the attached Exhibit A in the News Journal and Delaware State News on before June 24th, and affidavits of publication of such public notices no later than July 1st, designates Mr. Kenton as hearing examiner, provides the deadline for petitions to intervene, and deadline for written public comments, and how those public comments can be filed in the commission's website. And with that, I respectfully request the commission's approval of proposed order 9418, opening a docket for this commission's consideration of forbearance over electric vehicle charging stations and service providers.
Thank you, Mr. Walsh. Mr. Slater?
Perhaps it is a matter of semantics, but first of all, the background is excellent, and I should have started off that way. The background really is solid, but I just don't agree that staff's petition and proposed order is your own motion. I think that you need to do it on your own.
Okay, Mr. Slater, thank you very much. I think I've already expressed my opinion. I'm going to ask if any other commissioners have any other questions of the parties. Mr. Willard? Not right now. You know, oftentimes the way things get to our attention is because we're part-time people. You guys are out there working full-time. So we depend upon staff to bring us issues like this, and the DPA to bring us issues like this so we can resolve them. So this is a perfectly natural way for business to get to this commission to make a decision. And I think I've already stated it, in my opinion, we merely adopt and make our own the application, petition, motion, whatever you want to term it, as our own, as well as staff's petition for the purposes stated by Mr. Walsh. And I think that we proceed forward and we see what the merits of it are and make a decision when you guys are ready to bring it back to us. Commissioners, any questions of the parties?
Mr. Chair, I'd like to make a motion that the Commission adopt order number 9418. Then I have a question when we have the discussion, please.
I second.
Commissioner Gray.
So as I read the scope and the course of this docket, if it's appropriate, I'd like to please also consider whether the PSC jurisdiction is appropriate when and if a vehicle-to-grid functionality is deployed with vehicle charging infrastructure. I didn't see that as I read through what the focus of the scope is going to be, but I would like to make sure that those of you who are discussing these issues, if vehicles begin to feed current back to the grid, does that then warrant that jurisdiction by the PSC is coming back to the table?
Mr. Walsh?
Well, I mean, no sarcasm by this, but if we open, that is part of the reason we open the docket, to vet those issues, get the information, and have more technical data, and consider that heightened level when it gets here. And I suppose part of the analysis will be, when will it be here? I think as an initial matter, we are taking the first step, which is the consideration of the forbearance due to the definition of the EV charging stations as public utilities under the Public Utility Act.
That's clear. I just wanted to make sure that I got that on the record because I didn't see it in the scope as it's documented currently. No further questions, Mr. Chair.
I just wanted to comment and say that in the actual order, it doesn't say this order approves a petition or even approves an application. It does say that the commission has become aware, and that's how we become aware is through various means. So it really, I think, appropriately reflects the fact that we have become aware over 18 months that, and longer, that there's interest in the EV market and that it's opening a docket. So I think it properly reflects what we want to do, not necessarily saying we approve a petition or an application. It says we want to open a docket, and that's, I think, what we want to do. So that's my comment.
Any more discussion?
One further question.
And, okay, all those in favor of the motion signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, everyone. Is there anyone here from the public that wishes to make public comment to the Public Service Commission? Dr. Brewer.
Thank you, Mr. Chairman. Mr. Chairman and Commissioners, just some brief comments. There's an evidentiary hearing in PSC docket number 17-0985, Delmarva Power and Light Company Energy Efficiency Program, July 10th and 11th, here at this very same hearing room. The commission meeting, as you had indicated earlier, for July 2nd is canceled because of the holiday weekend. The next commission meeting will be July 16th, 2019. I do not have any other comments, and at this time, I would like to ask that the commission go into executive session in which only people in attendance will be Matt Hardigan, Connie McDowell, Donna Nickerson, Courtney Stewart, Deputy Cabinet Secretary, she's here at your invitation, and Tom Walsh. All other folks should clear the room. Thank you.
Before I make a motion, Mr. Chair, I'd like to take this moment just to send some major kudos to Mr. Josh Bowman for the multiple disc analyses in today's dockets. Keep up the great work. Now I move that the commission move into executive session for the purpose of...
I think we should add Ms. Gannon's name to that as well. So thank you, Trish.
Second the motion?
Is there any discussion on the motion? All those in favor signify by saying...
There was no second on the motion?
Second.
Okay, thank you.
Signify aye.
Aye.
Any opposed? Any abstention? Motion carries. We're now in executive session.